SME Helpdesk. So I just want to see here, Matias, do we have you with us?
Yes, but for sharing my, there we go. For sharing my PPT.
Can you try and speak again, Matias? We just want to check that we have the sound in order.
Yes, can you hear me?
We can hear you loud and clear and see you as well. Perfect.
Perfect. So today I will talk briefly about how to protect intellectual property. Especially, this is particularly useful for those companies that wants to internationalize themselves into China. Let me see if I can control. There we go. But first, I will introduce our help desk. In the China IPR SME Helpdesk, we are an EU-founded project. Our purpose is to support SMEs when they try to go to China to start doing business, facing this internationalization process. Particularly, we help them with intellectual property protection. All our services are free of charge, and we provide the helpline. We organize webinars like these ones. We also arrange trainings. And most important for SMEs, we provide materials like guides and infographics that you can check in our website. So feel free to visit our website and see all kind of materials for self-learning, like the ones you can see on the screen. About intellectual property rights in China. Generally speaking, when we talk about IP, we are basically talking about a bunch of assets that they provide the monopoly for companies over certain specific acts in order to avoid certain companies to do them. When we talk about innovation patents and utility models, what we are protecting are products and processes. These are particularly useful for technologies because these are the innovative parts of a new technology. In the case of design patents, what is being protected is the aesthetic aspect of a product, what is the ornamental, how it looks, how it is presented to consumers. In the case of trademarks, also how the product can be distinguished from their competitors. It's what is protected. This means that any sign that helps a company to be different from the competitors can be protected as a trademark. In the case of copyrights, what is protected is an expression of an idea. For SMEs and green tech companies, this is particularly important in the case of software and databases. And finally, the last IP rights that we will be addressing today is trade secrets, which sometimes it is forgotten, but it's very relevant. But we will see it on details later. Also, we have to know that in China, there are two main principles, actually in every country, but these are particularly important for China. The first one is called registration principle. That means that in order to have IP protection in China, we need to register the IP in China. We have to remember that in the case of China, we have 4 different jurisdictions. We have mainland China, Hong Kong, Macau, and Taiwan. So if we want full protection within the entire territory of the country, we need to have a registration in every single jurisdiction. And the second principle that is relevant is a territoriality principle. This one says that any protection that we have in the EU will not grant any protection in another country. So the protection we have in the EU will not grant protection in China because the protection only grants, allows you to enforce the intellectual property rights within the territory of the country in which was registered. But let's jump directly to each single one. In the case of inventions, how to protect a new technology? How can green companies protect the new innovations that they are developing? There are 2 different alternatives. In the case of China, we can protect them with innovation patents, or we can protect them with utility models. What we can protect with these IPRs are products. This is the final outcome of the manufacture process. It is the product itself and all the innovations contained in this product. Or what we can protect is the process of how this product was done. In the case of green companies that they want to include this circular economy and reuse materials and how they can be used and how they can take advantage of already used materials and how they can reduce costs, for example, because a process that produces the same product, but they can do it with less cost or more efficient or using less energy. This is already something that can be protected by the patent. Then we have to check if we comply with the requirements, which are novelty. This means that this new technique that the company is using should be new, should be unknown. It should be non-obvious. This means that it should be innovative, that any expert on the field that looks at the current existing technology shouldn't come up with the new patent, for at least not easily, because it shouldn't be obvious. And finally, it should have industrial application. It should be replicated. It should be possible to be replicated industrially. In China, for registering innovation patents and utility models, we have two different alternatives. The first one is going with the China National Intellectual Property Agency. We directly register with them. Companies that are based in China can do it without the need of an agent. However, this is highly not recommended because the process itself is so complicated that the assistance of an expert it's very advisable. The second option would be doing the registration with the PCT. The PCT is an international agreement that allows companies to expand their protection, their patent protection to certain jurisdictions. The advantage of PCT is that companies can start the registration in their own language and in their own country using their own IP agent. But what are the differences between innovation patents and utility models? How we can decide what type of intellectual property right to use? Both intellectual property rights share the same requirements. They protect the same aspect. They protect the same object. However, when analyzing or when doing the registration process, the agency is less strict regarding the utility model. Also, utility models are much faster to be obtained. While innovation patents normally takes from 3 to 6 years, utility models takes around 1 year. So another difference is that, or another aspect to take into consideration when deciding what type of IPR to choose, is that innovation patents, when they are being registering, they do not grant any type of protection. So while the patent is pending, companies cannot enforce them. This takes to the scenario in which companies actually do a parallel registration. They choose both methods at the same time. The reason is that they obtain first the utility model. So this will be obtained within 1 year. They can start enforcing it. And then when the patent is granted, after, for example, 6 years, then they discard the utility models and keep using the patent protection. This way, they have a method of protecting the technology while the patent is pending, and then they have the 20 years protection of the patent while it is granted. For those green companies that they have developed a software, and the software is actually the main or the core part of the technology, they should know that even though software normally in China is protected by copyright, in certain specific scenarios, software can be protected also by innovation patents. These type of patents are, I would say, the exception more than the rule. And they only grant protection in those cases that the software is connected with a more complex process in which the software, also in connection with hardware, is the one that is solving the technical problem that the patent is trying to solve. So this means that in this long or this more complex process, the software is the one in charge of solving or adding the difference, the innovation part, that the hardware itself cannot do it without the assistance of the software. Trade secrets. This type of intellectual property rights, as I mentioned before, sometimes it is forgotten. Companies do not pay enough attention to them. This type of intellectual property rights is not registered. Actually, by definition, you can register a trade secret. Because what's a trade secret? It's any information that the company has that is first a secret. This means that it shouldn't be known by the vast majority of the competitors in the market. It doesn't mean that only your company should know this information. As long as it's not known as for many of competitors, it could be protected as trade secret. Also, it should have value for being a secret. This means that it should provide your company with a competitive advantage. Finally, this trade secret should be protected with what is called protective measures. The protective measures can be differentiated into 3 categories. The first one is physical. Your company directly creates physical barriers in order to have access to the technology. For example, this could be by locking a prototype into a specific room, or simply with the seal or the stamp of top secret or confidential in the document. This is a physical barrier. There are also technological barriers that, for example, with the usage of a server that not every employee has access to. Finally, we have legal measures, protective measures, that normally this is connected with the usage of NDAs or non-disclosure agreements. These are agreements in which companies agree of disclosing certain information, but with the compromise of not releasing or not disclosing this information to third parties. Otherwise, they will have to compensate. The amount of protective measures that the company should apply in order to protect the trade secret should be reasonable with the value of the trade secret. This means if the technology is going to be significantly important, then the protective measure should be very strict. However, if it is only a simple advantage but not highly relevant, then it's not necessary to be really strict. In order to know when to protect the technology as a trade secret or as, for example, with an innovation patent, we have to take into account different factors. In the case of SMEs, sometimes the most important one is that how expensive it is to register the technology. If the company do not have the budget for facing the registration process, but they still want to perform businesses in China, then they can consider using trade secret as a method of protection. But this is also connected with the second factor that is relevant, that is the possibility of reverse engineering. If the technology can be learned by reverse engineering, then most likely trade secret protection is going to be impossible, because as soon as your company releases your products in the market, your competitors can buy them, study them, and learn everything from them. So in this case, there won't be any chance of trade secret protection. But let's start with our first case study. It's about a Dutch company that produces chemicals in order to combat dust. Their technology has 3 main advantages. The first one is that it's biodegradable. The second one is that it was cheaper to produce than the one that were producing their competitors. And the third one is that they believe that the life of the technology would be longer than the life of a patent. This is longer than 20 years. According to the estimations, this technology could survive or could be still commerciable for a longer period of time. So when they decided to enter the Chinese market, they have to analyze if they want to protect the technology as a trade secret or as a patent. And they started analyzing different factors. The first one is that the technology or the components of the technology were produced in the Netherlands. So they didn't need to disclose how to produce them to a Chinese party or to a branch of their company in China. Second, it was not possible to be discovered by reverse engineering. The third one is that they didn't have any type of protection by patent in any part of the world, not in Europe, not in Asia, not in China. So this technology was not ever published because, as you may know, when you file a patent, eventually it will be published. So if you have a patent in the EU, then technically speaking, it is possible to have access to them from any part of the world. So with this, if they would have protected the technology with the patent, it would be impossible to talk about trade secret protection. And also they realized that even if they decide to go with the registration of the patent and protect the technology with the patent, in the case of an infringement, it would be impossible for them to enforce it. The cost of hiring a lawyer, of doing surveillance in China, of facing the long term of having a competitor using the technology till they can enforce the patent, it was impossible for them to afford. So with all this combination of factors, they decided to go with the trade secret protection instead of a patent. So what we can learn from here is to have an expert assistance, because for having a trade secret protection, they also contacted experts about how to protect trade secrets. They didn't disclose any information ever, so it's important to always, before deciding the strategy, just in case, to protect every single information as a trade secret. And they were, in this case, they were also investing in having good and enforceable NDAs agreements. But let's go with trademark protection. This is something that sometimes companies that are too much involved in technology, sometimes they tend to forget or to underestimate. Because with trademark protection, what we actually are protecting is the business of the company. We can protect with the trademark the company name, or we can protect your product names. So what we are protecting here is the investment of a company in advertising. What we are protecting is the reputation of a company. And in the case of green technologies, the reputation is significantly important. For registering a trademark in China, we also have two different alternatives. The first one is going again directly with the China National Intellectual Property Agency. We can file the registration in Chinese language with them. We don't need the assistance of an IP attorney if we have a company based in China. If not, we need the assistance of a trademark agent. But also there's another international agreement that allows companies to expand their trademark registration to certain jurisdiction, that is the Madrid system. This method is quite effective. It takes a little bit longer. Normally, a trademark is registered between 6 months and a year. With the Madrid system, I would add 2 more months. But also we have to take into consideration that trademarks are divided into classes and subclasses. This means that a trademark can be classified according to their type of product or service that they are protecting into 45 classes, 34 for products, 11 for services. Each class has different subclasses. A same trademark can coexist with different owners in different classes, and as long as there is no confusion for the consumers, between them. And we have to take into consideration when using the matrix system that there is a difference between not the classification of the classes, but yes, with the subclasses. So when we are using the matrix system, we have to pay attention that when choosing the subclasses that will be protected, that they actually match the type of products or services that we are trying to protect. Regarding the requirements for trademark protection, the first one is legal. Trademarks should not be, there are certain trademarks that are not possible to be registered, but normally these are connected with symbols of countries like flags, shields, this type of aspects. It's not, normally they're not very relevant for companies. The trademark should not be functional. It only should be able to help your product to be distinctive, but if it is functional, if it provides an advantage, then we have to go to a different type of protection, which could be innovation patent or utility model. Also, the trademark should be distinctive. This means that it should be different from the existing ones, at least in the same class, and it should be available. This also means that companies, that they shouldn't be a similar one in the already registered. In the case of China, it's relevant to highlight a characteristic that is the trademark translation, because some consumers are not capable of reading our alphabet the same way a non-Chinese speaker is not capable of reading the Chinese characters. So what companies normally do is to do a translation of their name into Chinese characters. This translation can be done phonetically. This means by replicating the sounds using the Chinese characters. They can be literal. This means if your trademark has a concept, just by doing a simple translation of the concept. And also, it could be a combination of both elements. That this would be ideal. Why it is important why branding is important for tech-intensive companies, as I mentioned before, because even though the most significant part of the main characteristic of a company is their technology or the impact that they may have in the, for example, in the case of green economies in the environment, companies should also protect their reputation. And they should make their products distinctive from the competitors. And every time a company is investing on their name and they are expending money on this aspect, trademark is a method to capitalize all this type of investments. Regarding exploitation techniques, how to get profit from our intellectual property rights, we have two main aspects. The first one is the licenses, in which your company will allow another company to use the technology. This usage can be restricted to certain specific characteristics or conditions. For example, limited to a specific territory, or limit the quantity of the number of products that the company can produce, etc. There are two different approaches about the usage of license. That is related also with enforcement. In case we find a company that is already infringing our IP rights and we don't have the resources to go to court against them, so we can use a license in order to solve this problem. A carrot license is to try to seduce our competitor, this infringing company, with the license, and the stick approach would be actually to threaten the company with the lawsuit if they do not have a license. In the case of license, we should know that certain level of know-how it's also transfer, not simply the intellectual property, the registered intellectual property rights, because normally license agreements involve certain training, certain exchange of information that goes beyond the protection of for example, a patent. This could be seen as a trade secret. So be careful when doing this type of license. Also, I would like to highlight that with the new patent law, there is an open license methodology in which companies will be able to go to the intellectual property agency and declare with a written statement that they want to make their technology available for anyone as long as they pay their fees. It's not that they're going to be for free. And this way, any company, any Chinese company that wants to use the technology can go directly to the agency, pay the fees, and use it without the need of further negotiations with the IP right holder. Also, it provides another benefit for these companies because the fees that they will have to pay for the patent will be reduced. I believe this is significantly important for encouraging green technologies because they avoid the stage of negotiations. All the conditions are set in advance, and they're very clear. So if the green companies set good conditions, it's a good method of encouraging the usage of green technologies. Finally, the last method of enforcement, of exploitation, is the sale of intellectual property rights. But in this case, the companies will be transferring the ownership, not only allowing a third company the usage. And finally, we have our second case study that is a German SME that they were producing drives that reduce the energy used by industrial machinery. They already had a patent, and they were looking forward to license this technology to different Chinese companies. So they started a round of negotiations with different companies and finally decided to go with one of them. After several years, they discovered that one of these companies they were discussing or they were negotiating as a potential client actually was infringing their own patent, even though they were not chosen as the licensee. And they were actually, the company that was actually chosen as licensee was actually complaining about this aspect. So the German company had to take a decision about how to proceed. And they discovered that if they decide to go with the lawsuit, they were also having the risk of having their patent declared null because one of the requirements was not entirely fulfilled. And also the invalidation of the patent would lead to the nullity of the license contract that they have with the Chinese company. So what they decided to do instead of going to the lawsuit is to use that money that they were receiving from the license and reinvest it in research and development and develop a new and better technology and protect it. And then they got a different patent and then they started licensing this new technology. So what are the lessons that we can learn from here? That when we are negotiating licenses and we are disclosing information, we have to remember to protect them as trade secrets. And also, when we have to take a decision about enforcement, we have to choose a plan that is affordable, that our company can go with. And sometimes going to the lawsuit is not going to be the best option. Sometimes there is a method of workaround and a different solution and actually end up in a better situation. So to finish, some takeaway messages. Remember to register your intellectual property right as soon as possible. Remember to protect your trade secrets. Hire an expert if it is necessary, because this can lead to the lack of protection in the future. Translate your trademarks into Chinese characters if you're planning to go to China, so they can be easy. It could be easier for consumers to remember them and could be easier for your company to become famous in China. License your technology to non-competitors so you actually get more resources out from them. Take advantage of the open license system that is going to be available after June next year, thanks to the new patent law. Conduct a due diligence before exploiting your intellectual property rights, because as it happened with the German SME, a company that was considering receiving the license of a technology end up using it and infringing, causing problems to this German company. Finally, if you have any questions, please feel free to contact with the China IPR SME Helpdesk. As I mentioned at the beginning of the presentation, all our services are for free. We have this helpline that is free, fast, and confidential, and we normally reply within 3 working days. And I think I'm okay with the time. Maybe a little bit longer, but
Thank you very much for the presentation, Mr. Matias Zubimendi of the China IPR SME Helpdesk. A lot of experiences and a lot of tips and even some case studies of the importance of securing your IP rights here in China. So for today's program, we are moving a little bit more around, and we are jumping now to